Remedies for breach of a contract. Now, just think if you enter into a contract with someone and that person does not fulfill the contract. That means there is a breach of contract. So, what remedies do you have? Think for yourself for a minute. What all can you do? Either you'll say, I don't want to get into this contract as the other party is not fulfilling its promise, which means you will rescind the contract, cancel the contract, right? Second option is if you have suffered any loss because of non-performance of the contract, then you can go to the court to claim damages. Damages here means monetary compensation. Now, there can be a scenario where you start the work under the contract, but the other party breaches the contract before completion of the contract. In such a case, you can claim payment for whatever work you have done under the contract. This is called suit upon quantum merit. Other than this, you can also insist upon specific performance of the contract. That means insist upon doing what had been agreed under the contract. Now, if a person breaches the contract by doing something which he is not supposed to do under the contract, then orders from the court to restrict such a person from doing so. This is called suit for injunction. Now, let's discuss each of these cases in detail. The first one is rescission of the contract. When there is a breach of contract by one person, the other party need not perform his part of the contract. However, if the aggrieved party wants to claim compensation and be free from all the obligation under the contract, then it has to apply to the court for rescission of the contract. Once court grants rescission, the aggrieved party is freed from all his obligation under the contract and becomes entitled to the compensation due to the loss of non-performance of the contract. Okay, hope this is clear. Now the second remedy is the suit for damages. That means filing a suit in the court of law for monetary compensation for the loss you have incurred. It is important to note that the damages here are a means to compensate the aggrieved party and not to punish the party who has breached the contract. The objective of compensation is to put aggrieved party in the same position had the contract been fulfilled. So, in order to claim damages, there must be some actual loss to be proved to the court. Damages cannot be claimed if there are no loss incurred to the aggrieved party. For example, Mr. A contracts with Mr. B to buy 1000 kgs of mangoes for 80,000 rupees. However, Mr. A later took delivery of 400 kgs of mangoes only and refused to take delivery of the remaining 600 kgs of mangoes. Mr. A also paid 32,000 rupees for 400 kgs of mangoes. However, since Mr. A refused to take delivery of 600 kgs of mangoes, those mangoes got spoiled in the godown, causing Mr. B a loss of 48,000 rupees. So, if Mr. B can prove to the court this loss of 48,000 rupees as a result of breach of contract by Mr. A, the court can grant damages amounting to 48,000 rupees to Mr. B. Clear? The damages must commensurate with the loss incurred. The court must maintain a balance and award the damages that are neither more nor less than the actual damage incurred by the aggrieved party.